May it please the court, Michael Lubes for the appellant Eric Dancy. I would like to reserve my 5 minutes of rebuttal at this time. The case is a pretty straightforward case. It's a residential foreclosure action involving an FHA insured loan. In this matter, obviously the pleadings form the basis of the whole argument here. The complaint pleaded conditions precedent sufficient to satisfy the plaintiff's burden under 9C. It's our position that paragraphs 10 and especially 11 of the answer pleaded the non-compliance with the 3 specific statutes under Title 24 of the Code of Federal Regulations applicable here with enough specificity and particularity that now under the court's Awadala holding is a condition precedent and places the burden of proof on the plaintiff. If we look at this case, specifically the appeal is on one section, 203.602 of Title 24. And in this case, the motion for summary judgment the plaintiff filed only mentioned a compliance letter and a notice of default that were filed in this case in saying that the conditions precedent were complied with. The affidavit of Dawn Bechtold in paragraph 5 lists a default letter as Exhibit A5 and a HUD compliance letter as Exhibit A6. There's no mention at all in the affidavit that any of those particular documents were specifically for compliance with any specific of the 3 sections that we put in our answer in paragraph 11. It just noted it was a HUD compliance letter. And I have conceded to the court, even though there was some language in the letter, the face-to-face letter, that was actually sent in compliance with 203.604. So the face-to-face issue we've taken off the table on our appeal. And so basically what we're looking at is the default letter that was submitted as Exhibit A5 and whether or not it complies with Section 203.602, 203.606A, neither or both. As you can tell by the various possibilities, it's our position that's a genuine issue of material fact, because it wasn't until the reply brief, after we had put in the mortgagee letters, because to back up a little bit, 203.602 and 203.606A say that those particular notices have to be sent in a form that's approved by the secretary. So in the burden of proof, if we're looking at what constitutes their meeting the initial burden of proof, one would imagine that if the answer has the specificity and particularity required under 9C to shift the burden of proof, at least those 2 regulations should be somewhere in the motion, or particularly in the affidavit, in the proffer evidence, whether it's testimonial or documentary. And in this case, there isn't any. It's not until the reply brief where, after seeing the HUD mortgagee letters, counsel for Lakeview has some very unkind things to say about those and the attempt to submit them as evidence. And I will concede that without the affidavit, they're not proper 56, even though they're self-authenticating and they're government records. They are not admissible because they were not accompanied by an affidavit as required under Civil 56. And eventually, I think it's under 56C, lists the things that are admissible evidence. Government documents themselves are not. However, the disparaging comments aside, in the reply brief, they didn't object to the admission of that. And I would point out, after I finish the reply brief in this case, that there is a case from the 9th District. It's Christie versus GMS Management Company. It's 124 Ohio, Appellate 3rd, 84. And specifically on page 90, it says that the court may consider evidence that's improperly before it but was not objected to. So I would submit the court could consider that. And then the issue with the mortgagee letters is that is the form that HUD says these letters should have. So under 203.602, it should have the language that's required under the mortgagee letters. And clearly, it's our position that it did not. But even if the court weren't to consider that and leave the evidence as just the proffer by Lakeview in this case. What we have here is, it just complies, trust us, we're the bank. There's no real showing, no averment, no documentary proof that that letter, that default letter, satisfied either 203602 or 203606A. Matter of fact, it came after the 2 months of a 2-month window that was required under 203602, within 2 months of a missed payment. They're claiming in their affidavit, in their complaint, that the first payment missed was March of 2014, and that letter came after the end of April. So in that case, it's non-compliant.
Was there some discussion about a grace period?
Well, that's the position of the bank. And certainly, if we're just staying in the four corners of the regulation, there is no grace period considered. It's a shall regulation. And we can argue about the timing, and I don't make a big issue of it because it is just, I think, a few minutes past, or a few days past the date. My issue, and Mr. Dancy's issue, is more with the composition of the letter itself, and the lack of the required language, and the attempt to use one letter to satisfy two regulatory requirements without some evidentiary proffer that one letter can suffice for two regulatory requirements, or that in fact it can't. What Lakeview has tried to do in this case is place the burden of that issue. And I know that this whole issue was being argued before Awadala, and so there was an issue of whether it's an affirmative defense or condition precedent, and as the court said in Awadala, that makes a big difference on who has to prove what. But now that we've crossed that bridge, we've come to that decision, and now it's their burden. So it would be our argument that really there is a genuine issue on that, and this needs to be sent back to the trial court for a determination of whether one letter can supply proof of both regulatory requirements, and if the actual content itself satisfied the requirement, because both of those, 203602 and 203606A, say that it has to be in a form provided or approved by the Secretary. And with that, I'll give back the rest of my time, if I still have 5 minutes.
Oh, you do. That's fine. Thank you.
Thank you.
May it please the court. Good morning, Your Honors. My name is Mike Weary. I represent the appellee, Lakeview Loan Servicing LLC in this case. Your Honor, as the arguments in this appeal are focusing on conditions precedent to the foreclosure, I'd like to start and state, just back up a little bit from the arguments of the appellant and say, what the conditions precedent are being examined, it's actually a two-step process for this court. And that doesn't change here today. The first step under that analysis is whether the conditions precedent specifically plead per Civil Rule 9C in the answer filed by appellant Mr. Dancy. If not, if you find that it does not, those arguments are waived. If and only if the answer to that question is yes, they do specifically plead, then an analysis begins as to whether and to what extent the conditions precedent were satisfied in the case. So let's start very briefly. I'll address both of those with you today. I'll start briefly with whether were the conditions precedent specifically pled in the answer filed by appellant. I would submit to you that they were not. I'll start by indicating that Civil Rule 9C states that in the pleading of performance or occurrence of conditions precedent, it's sufficient to divert generally that all conditions precedent have been performed or have occurred. I think we heard from appellant, we did that in our complaint, and the problems there. However, a denial of performance of occurrence shall be made with specifically and with particularity. I note that under Civil Rule 9, I looked up those words the other day, specifically and particularity, and they seem to be very similar to each other. However, the civil rules have made it a point to state both of those in that sentence, specifically and with particularity. Fraud, for example, is also under Civil Rule 9. It only has to be made with particularity. There's another pleading special damages that only have to be specifically. However, for some reason, when Civil Rule 9 was drafted, they used both words for conditions precedent. What does that mean to you today? I think it means that it has to be very specific. So let's take an examination of the language used in the appellant's answer as to the conditions precedent. He indicates that plaintiff failed to complete all HUD servicing requirements prior to accelerating the debt and initiating the foreclosure action, as required under an E-State 24 CFR section 203.606, including but not limited to, very general language in my opinion right there, 24 CFR 203.602 and 203.604. Although I'm aware the court has had some analysis on the language of specificity before, I would urge this court to examine this type of language further. Although appellant cites the CFR sections in his answer, he fails to state how we violated those sections. That's what 9C's specificity and particularity requires here. For example, pleading fraud, and I'll just use this example for the court. When you plead fraud, you can't just, there's been a number of cases, and I'm sure this court's had a number of cases before them, you can't just state with fraud, these are the elements, this is, they were of fraud, and just blankly state those elements, and then ask for relief. Fraud is also under Rule 9B. You actually have to state operative facts under fraud, which actions took place, how the victim of fraud relied upon those actions, and the damages that were suffered as a result. And again, I said fraud is the only requirement is that's pled with particularity. I think to reach the level of specific and particular pleading, you need to go beyond just citing those code sections and dropping them in as the appellant has done in this case. There's multiple subparts of these sections. In fact, in this particular case, appellant even splits HUD 24 CFR 203.606 into 3 separate portions. What portion of that are we violating? Now, we hear what portions here in summary judgment, we hear them in the appellant arguments today, but I would submit to you that Rule 9 and the specificity requirements require those to some extent, at least beyond just citing the sections in the pleadings of the defendant in the case. And that just simply wasn't done here. Okay, so I'll move on to the second part of the argument, and that is the analysis of whether and to what extent the conditions precedent were satisfied. Okay, I heard some discussion about the timing of the letter that was sent. This is, when I say the letter, I'm referring to Exhibit A5. We're calling it the default letter in this case. Appellant argues that the default letter dated May 6th, which the appellee sent to the appellant, was at least 6 days late. Calculating the time of when that letter has to be sent, this is how you calculate it. It's the end of the second month of any delinquency. I find that a little hard to follow in calculations. The defendant was due for a March payment, which wasn't made on March 1st. Therefore, I think the appellant is calculating the end of the second month of the delinquency as April 30th, 2014, and that's from his calculations. We are submitting to the court that Section 6A of the note provides a 15-day grace period for making the payments. So basically, ironically, borrower argues that the default letter should have been sent sooner, actually arguing that we didn't default the borrower, his client, soon enough, and that the 15-day grace period for making a payment should not count in the calculation of how soon that letter must be sent. Now, if you look at the instrument, we can't collect a late charge, quote unquote, as it's called in the note. until that 15-day grace period is passed. The payment, why? Because the payment isn't late until then. So I don't think it's unacceptable that the 15th day of the month could be used to calculate this quote-unquote end of the second month of any delinquency. I mean, after all, couldn't late be interpreted to mean the same as delinquent? Counsel for the appellant also indicated that there were some evidentiary issues that we pointed out with some of the attachments that he submitted to the court. He attaches some bulletins from HUD, and he also attaches a website printout, I think he mentions. I would ask that you scrutinize those closely. I think he's actually calling those an issue himself when he's up here before you and trying to determine, and then he's saying that we didn't object to those. We've made the arguments against those. We pointed those out to the court. This is a de novo review of the summary judgment. I think that those are the types of things that this court is empowered to review in this type of situation. If that evidence wasn't sufficient under Rule 56C, which it must be, we would ask that you analyze that. We would submit that it is not sufficient. He does cite some evidentiary rules and asks and submits that it's self-authenticating. We would disagree with that. I'm not sure if I understood counsel correctly, but I think he might be indicating that that the appellant is second-guessing that evidence at this point as well. There's no affidavit that accompanies these bulletins or printouts. I've commonly seen in cases where people print out website materials for submission to the court, at least accompanied by some sort of an affidavit by maybe an attorney or a law clerk that indicated that they did the research and printed that out. There's nothing of the sorts here. Therefore, I would ask that that evidence be discounted in reaching your decision. I think counsel has indicated that he has no arguments under the HUD face-to-face interview, section 203.604. Therefore, my argument is substantially shortened before you today. In closing, Your Honors, the appellant.
What about the composition of the notice to default, that we call it, that both in one letter and so forth, and
Sure.
the requirements?
Sure, Your Honor. I'll start by saying 203.502 indicates that a letter, the statute itself, if you read the statute, or I'm sorry, if you read the federal regulations, CFR, it doesn't necessarily lay out the line item things that are supposed to be included in that letter as the appellant points out to you. In fact, I read it in the brief and I'm thinking, like, that must be what it looks like in the statute, and then you go to the statute and it's not that. In fact, it doesn't even mention it. It says it has to be on a form prescribed by the secretary, or it can be on your own form if it's approved by the secretary. And then he gets into citing, these are the requirements, and that's kind of where I get into that evidentiary issue as to whether that should be admitted or not. However, I would indicate that the letter that we sent complies. We start with CFR 24 section 24 CFR section 203.606, and then he's backing into saying that 24 CFR 203.602 needs to include certain items. I would say that our letter substantially complied with that section of HUD. That doesn't have to be 3 separate notices, okay? It doesn't have to be a face-to-face letter, a default letter, and then this letter that he's indicating under 203.602. You can actually combine. There's nothing in that statute that says it has to be separate, even though I think he's represented that to the court. The HUD face-to-face letter is something that's normally sent separately, but the default letter often combines and includes the requirements under 203.502 that he's indicating to the court. So if you look at the content of that default letter, the letter notified Mr. Dancy of the following: that he was in default under the note, he was in default under the mortgage. The amount due and owing to cure the default was indicated. It indicated additional payments, fees, or late charges that have become due or may become due. That the payment to cure this amount must be received within 30 days of his receipt of that. It further notified Mr. Dancy that failure to cure the default would result in acceleration of the loan and the foreclosure proceedings. It provided a toll-free number. I think we see him indicating that toll-free numbers are part of the requirements. It provided a toll-free number for Mr. Dancy to contact the lender representative to talk about loss mitigation options. It further provided a toll-free number for a HUD counseling agency. And it also added a link to a website called Payment Help, which is something that if you were to click on that, it would take you to the website for the lender and present a number of options and ways that you could seek help in foreclosure. We have no evidence before the court that Mr. Dancy did not receive this letter with the information, nor is there evidence that Mr. Dancy was damaged as a result of the letter, possibly not including such things as appellant alleges. For example, a Spanish wording at the top of the letter. I will submit to you that our letter did not include that. However, I think that it's within the power of this court to decide whether that letter substantially complied with this HUD regulation, and I would urge you to find that it does. Therefore, Your Honor, in closing, the appellant argues to you that there are genuine issues of material fact that you should, and as a result, you should overturn the trial court's granting of the motion for summary judgment. Appellee submits that the trial court did not err in granting the plaintiff's motion for summary judgment, and therefore asks this honorable court to affirm the decision of the trial court. Thank you, Your Honors.
You have your 5 minutes remaining.
I won't take 5 minutes, I promise. I would just tell the court, read paragraph 11 of our answer. It even says, Civil Rule 9C. If it's their position that we have to actually block quote in an entire section of the Code of Federal Regulations to meet the burden under Civil Rule 9C, then yes, we didn't do that. But the thing that is intriguing to me is they're a regulated financial institution. How can they not know what's required to be in the letters they have to send? They're the beneficiaries of FHA insurance. It's not the borrower. FHA insurance is in case the lender suffers a loss. And these requirements are additional requirements placed on the lender to try to mitigate defaults so that the federal government doesn't have to pay off on the insurance claim. Certainly they have people at Lakeview that are in charge of FHA loan portfolios that know the regulations. It shouldn't come as a surprise to these people when they cite these regulations of what's supposed to be required. If you look at 203-602, which is included, I believe, in both of our briefs, and I know in my brief in opposition, I mean, it starts out by saying the mortgagee shall give notice to each mortgagor in default on a form supplied by the secretary, or if the mortgagee wishes to use its own form, on a form approved by the secretary. That's pretty clear language, that there has to be a certain format to that. This is great argument that Mr. Wary has given us, but there's no evidence in the record. Not testimonial evidence by the affiant. There's nothing on the four corners of either of the documents, especially not the default letter itself, that says it's in compliance with either 203-606A or 203.602. It's just not there. It's just not there. And then I would note on the timing issue, the last clause of that first sentence says, no later than the end of the second month of any delinquency in payments. It doesn't say 60 days after payments due. It says no later than the end of the second month of any delinquency in payments. So it's not our position that the 5 or 6 days outside the window is that big of a deal. But when it says shall in the third word of a regulation, and it sets forth a specific timeline, and the mortgagee in this case, Lakeview, doesn't comply, they're out of compliance. So with that, I would just say to the court, this judgment needs to be reversed, it needs to be remanded back to the trial court, there needs to be a trial on this, and with that, I would ask that the court so hold.
Thank you. Thank you, counsel. Thank you both for your presentation. Arguments to the court will take the matter under advisement. Thank you. Your written opinion and be sent to you, and